No injured person should ever sign forms, release form, or give a recorded statement to an insurance adjuster before a thorough consultation with an experienced personal injury lawyer. And there's a couple of reasons for that. The signed release, for example, the form that they're asking you to sign to resolve your case is always going to include a release of liability. And what that means is that once you sign that release, you are never, ever going to be able to recover another dime for your injuries. You may have further complications. You may have injuries that you didn't know about. You may not have accounted for health insurance and how that fits into the equation, and liens that medical providers or other insurance companies may have that entitle them to a portion of those proceeds. And if you haven't accounted for that information because you don't have the information that you need in order to be able to analyze that, then signing that release is going to be a costly mistake. People ask me, should I give a recorded statement after an accident? This happens a lot of times after an accident. A friendly and courteous insurance adjuster will call a person and say, hey, I'm the adjuster from ABC Insurance Company. I just wanted to ask you a few questions about this case. Do you mind if I get a recorded statement? I just need to know what happened so that I can resolve this case for you quickly and cleanly. And they'll ask you questions. What happened? Where were you going? Why were you going there? And most of those questions are innocuous and not harmful to your case. But interspersed in those questions are going to be some questions that are very carefully designed to undermine the value of your claim. For example, one that is almost always asked is, once you've said, well, this is what happened, another driver wasn't paying attention and rear-ended my car and caused a great deal of damage, and I was injured. Well, one of the questions that an insurance adjuster is going to ask you under those circumstances is, after he hears or she hears all about what the other person did, they're going to sort of calmly and courteously and politely ask you, well, was there anything different that you could have done maybe to avoid the accident, just in a calm and innocuous way? And there's always something that we could have done to avoid an accident. Maybe we could have taken a different route. Maybe we could have left earlier or left later. Maybe we could have looked in our rearview mirror, seen that somebody was coming up too fast behind us, and pulled ahead. There's always something in hindsight that you can do to avoid a negative consequence. But they may use that information, and they will use that information to try to argue later that you contributed to the accident by your doing something or you're failing to doing something. They can turn that information into a basis for denying your claim and a basis for saying that this accident was partially your fault. And in North Carolina, if an accident is partially your fault, you can recover nothing by law.